And what page are you on the RL?
It's item 19. So welcome back everyone to it's page 4, the top of page 4, to our summer series where we're doing our car forms trainings on Thursdays at 9 a.m. I appreciate you joining me. No video today. I'm joking. I'm starting my video. Thank you. See, this is why I have a handy dandy assistant, because I forget things like this. Anyways, we are finishing up. Last week we got halfway through. Last week we covered the seller in possession after the close of escrow, the SIP form, which you use for 29 days or less after the close of escrow. And if it's 30 days or more, we use the RLAS, or the residential lease after sale. And we didn't get all the way through that. We got through item 18 or section 18 on that. So we're going to cover 19 through the end of that today. And then we're going to jump back into our regularly scheduled forms for today, which were the contingency for the sale of the buyer's property. And hopefully we can also get through the seller's purchase of replacement property. So that's our plan today. As always, if you have any questions, I do have the chat box open, and feel free to just unmute yourself and be like, wait, Amy, I've got a question. Don't go on. I try to stop and ask if anybody's got questions as we go through this, but never hesitate to interrupt me or throw something in the chat box or raise your hand. I do have your little wonderful faces pulled up as well so that I can see your wonderful faces. So if you raise your hand, it usually pops up. And if you're watching this on the recorded version, feel free to throw any questions in the comment section or reach out to me directly if you have questions after going through this form. Does anybody have questions before we get started today?
No, ma'am.
No.
All righty. Fabulous. Good morning, Maya. All right, we're starting with section 19, entry. The tenant shall make the premises available to housing provider or housing provider's representative for the purpose of entering and making necessary or agreed repairs, including but not limited to installing, repairing, testing, and maintaining smoke detectors, carbon monoxide devices, and bracing, anchoring, or strapping water heaters, or repairing dilapidation relating to the presence of mold, providing decorations, alterations, or improvements, or supplying necessary agreed services to show premises to prospective or actual purchasers, tenants, mortgagees, lenders, appraisers, contractors, and other collectively interested persons. Tenant agrees that housing provider, broker, and interested persons may take photos of the premises. So right there, right, we've given permission to access it for basically any reason that the buyer might want to access it. Maybe they were going to rent the property out. They've gotten permission to show the property, to go take pictures of the property, to make any repairs to the property. If you've got a tenant in there longer than that 29-day period, which would be this RLAS. So, right. So when we covered the SIP last week, I said, hey, on the SIP, it's probably in the best interest of the buyer if they don't have too many repairs or mess up the seller too much during that time period, only because it's a short period. They're only in there for 2 to 4 weeks. With that 29 days or less. And so if you've got roof repairs or exterior repairs, do those, but the seller's trying to gather up their stuff and move out of there and get out of the property. So it's best to just kind of leave them alone is my recommendation on the SIP. Now, when it comes to the RLAS, we're talking 30 days or more. It could be 60 days, could be 90 days. It could be 6 months that they're staying in the property after the close of escrow. The buyers should feel like they have the ability to do what they want to do to that property. So if there were some repairs that needed to be done, pest repairs, roof repairs, whatever that might be, if they're going to rent it to show it, that's their 19 gives them permission to do so. The housing provider and tenant agree that 24-hour written notice shall be reasonable and sufficient notice, except as follows. A 48-hour written notice is required to conduct an inspection of the premises prior to the tenant moving out, unless the tenant waives the right to such notice. If housing provider has in writing informed the tenant that the premises are for sale and the tenant will be notified orally to show the premise, that's the car form NSE, then for the next 120 days following the delivery of the NSE, notice may be given orally to show the premise or actual or prospective purchasers, right? So notice needs to be done in writing, not orally. So text messages actually do usually mean that it was in writing. That is in writing. So there you go. But it's always good to drop a notice off as well. No written notice is required if housing provider or tenant or orally agreed to entry for agreed services or repairs. if the date and time of entry are within 1 week of the oral agreement, and no notice is required to enter in case of emergency, if the tenant is present and consents at time of entry, or if the tenant has abandoned or surrendered the premises. If checked, the tenant authorizes the use of a key safe lockbox to allow entry into the premise and agrees to sign a key safe lockbox addendum, car form KLA. So for the most part, residential lease after sale, it's usually not for an extended period of time. It's usually like 30 days or 45 days or 60 days. You probably want to check this box, because oftentimes what we do is we don't actually hand the keys over to the buyer directly. We leave them in the lockbox for the time period that that property is occupied by the seller. So we may want to check this box and include that KLA form if you're going to leave the keys in the lockbox versus hand them over to the buyer. However, keep in mind too, this is also really intended for like if the property will be resold or showings, and people are going to be accessing that lockbox outside of the buyer who now owns the property. Any questions about section 19 entry?
No, ma'am.
All right. Photographs and internet advertising. In order, oh, you know what? I remember here, I can like make this go away. And it makes this bigger for you guys. There we go. Photographs and internet advertising. In order to effectively market the premise for sale or rental, it is often necessary to provide photographs, virtual tours, and other media to interested persons. Tenant agrees that broker may photograph or otherwise electronically capture image of the exterior and interior of the premise, images for static and or virtual tours of the premise by interested persons for use on broker's website, the MLS, and other marketing material and sites. Tenant acknowledges that once images are placed on the internet, neither broker nor housing provider have control over who can view such images and what viewers may make of the images or how long such images may remain available on the internet. Tenant is advised to store or otherwise remove from view anything of personal nature for which the tenant would not want to appear in images, including but not limited to family photos, documents, and other valuables. The tenant acknowledges that prospective interested persons coming into the premise may take photographs, videos, and images of the premise. Tenant understands that broker does not have the ability to control or block the take and use of images by such persons. Once images are taken and are put into electronic display on the internet or otherwise, neither broker nor housing provider has control over who views such images or what the viewers may make of those images. So photographs, you can take photographs. Any questions about photographs and internet advertising, section 20?
I do. Sorry, I jumped on late. So I heard just a little bit of it, but so basically, if you don't want your photographs to be on the internet, take them down or cover them up.
Yes, if there's something that you would not want to appear in a photograph or on electronically as a tenant, they should take care of moving that stuff in. They should pack it up and get ready to move.
So if like let's say that there's photographs, you know, before and like they had it up and then they didn't sell their house and those photos are still on there, is there a way for us to be able to remove those photos?
Yeah, so this specifically is the RLAS, which is the residential lease after sale. So this is talking to the seller as a tenant, so the property is sold. But that being said, yes, so there's a little button inside the MLS that you can go in and click, and I don't remember what it is because they just recently added it. But if you go into your listing information, and I don't remember if it was in the photograph section or if it's in the regular section, but it says that the once it's sold, that the photos get removed from being disseminated, basically. And we can look at that further on a future lesson. We can pop it open and see what that was. But if you click that box, then once it goes to sold, then it stops pushing those photos out. Now, that being said, there's no way to necessarily like pull them off places like Zillow and Realtor or, you know, all those other places. So it doesn't necessarily remove those photos from those sites, but it stops continuing to show them as part of the feed.
Okay, gotcha.
Yeah. All right, section 21 is signs. Tenant authorized housing provider to place for sale or lease signs on the premise. Section 22 is assignment or a subletting. Tenant shall not sublet all or any part of the premise or parking or storage areas or assign or transfer this agreement or any interest in it without housing provider's prior written consent unless such consent is obtained. Any assignment, transfer, or subletting of premise or this agreement or tenancy by voluntary act of the tenant, operation of law or otherwise, shall at the Option of the housing provider, terminate this agreement. Any proposed assignee, transferee, or sublessee shall submit to housing provider an application and credit information for housing provider's approval, and if approved, sign a separate written agreement with housing provider and tenant. Housing provider's consent to any one assignment, transfer, or sublease shall not be construed as consent to any subsequent assignment, transfer, sublease, and does not release the tenant from the tenant's obligations under this agreement. This prohibition also applies to short-term vacation and transient rentals, such as, but not limited to, arranged through Airbnb, VRBO, home away, or other short-term rental services. So the default is it applies to those. If it doesn't apply to those, you would check the box there. Any violation of this prohibition is a non-curable material breach of this agreement. Any questions about section 21 or 22, signs or assignment subletting? All right, section 23.
What happens if you have an if your tenant doesn't agree to any of this?
This is all being signed before the close of escrow of the property. And so if not all parties agree to this, this ultimately should be submitted with the purchase agreements for the residential lease after sale, for something that's going to take place longer than 30 days. And if they don't agree to this, then the transaction should never be agreed to in the first place. And let's say that we didn't negotiate this up front. We're in contract on a property. Now the seller says, oh, can we have a rent back of 60 days? And you're like, yeah, sure, no problem. Here's the terms. Then if they didn't agree to it, then it would just be that, sorry, you've got to move out at the close of escrow. Like legally, that's what we've agreed to at this point. So you either agree to this up front, or we agree to that they're going to move out on the close of escrow and we try to add this in. And if they don't want to add it in, or they don't agree to it and we can't come to an agreement, then they don't get to stay after the close of escrow.
Okay, thank you.
Joint and individual obligations. If there is more than one tenant, each shall be individually and completely responsible for the performance of all obligations of the tenant under this agreement, jointly with every other tenant and individually, whether or not in possession. Tenant's obligations upon vacating the premises. Upon termination of the agreement, tenant shall give housing provider all copies of keys and any opening devices to the premise, including any common areas. Vacate and surrender the premise to the housing provider empty of all persons and personal property belonging to the tenant. Vacate any and all parking and or storage space. Clean and deliver premise as specified in paragraph C below to the housing provider in the same condition as referenced in paragraph 10. Remove all debris, give written notice to the housing provider of tenant's forwarding address. And then there's a blank there in case you need to fill something else in. B is all alterations, improvements made or caused to be made by tenant with or without housing provider's consent become the property of the housing provider upon termination. Housing provider may charge tenant for restoration of the premise to the condition it was prior to any alterations or improvements. C is the right to the pre-move out inspection and repairs as follows. After giving or receiving notice of termination of tenancy, CAR form NTT, or before the expiration of this agreement, tenant has the right to request an inspection of the premise to take place prior to the termination, CAR form NRI. If tenant requests such inspections, tenant shall be given an opportunity to remedy the identified deficiencies prior to termination. Consent with the terms of this agreement. Any repairs or alterations made to the premise as a result of this inspection, collectively repairs, shall be made at the tenant's expense. Repairs may be performed by tenant or through others who have adequate insurance and license and are approved by the housing provider. The work shall comply with applicable law, including government, permit, inspection, and approval requirements. Repairs shall be performed in good, skillful manner with materials of quality and appearance comparable to the existing materials. It is understood that exact restoration of appearance or cosmetic items following all repairs may not be possible. Tenant shall obtain receipts for repairs performed by others, prepare a written statement indicating repairs performed by tenant and the date at which such repairs, a date of such repairs, and provide copies of receipts and statements to housing provider prior to termination. Paragraph 24C does not apply when the tenancy is terminated pursuant to California Code of Civil Procedure 1161-2, or 4. Any questions about the tenant obligations upon vacating the premises? Okay. Breach of contract, early termination, in addition to any obligations established in paragraph 24, in the event of termination by the tenant prior to completion of the original term of the agreement or any extension, tenant shall also be responsible for lost rent, rental commissions, advertising expenses, and painting costs necessary to ready the premise for re-rental. The housing provider may withhold such amounts from tenant's security deposit. Okay. So right here, right, it's, hey, if they are in breach and they have early termination, we're actually stating in here that they could be responsible for the lost rent. So the rent for the entire time period. Temporary relocation, subject to local law, tenant agrees upon demand of housing divider to temporarily vacate premise for a reasonable period to allow for fumigation or other methods to control wood destroying pests or organisms, or other repairs to control fumigation or other work, including bagging or storing food and medicine, and removal of perishables and valuables. Tenant shall only be entitled to a credit of the rent equal to the per diem rent for the period, the time the tenant is required to vacate the premises. So if they were treating termites and the tenant needed to vacate for 5 days, you would take the total amount of rent, divide it by 30, multiply by 5. They would reimburse the tenant that amount of funds for the days they asked them to vacate the premise. Damage to premise, if by no fault of tenant, premise are totally or partially destroyed by fire, earthquake, accident, or other casualty that render the premise totally or partially uninhabitable, either the housing provider or tenant may terminate this agreement by giving the other written notice. Rent shall be abated as of the date the premise became totally and partially uninhabitable. The abated amount shall be the current monthly rent prorated on a 30-day period. If the agreement is not terminated, housing provider shall promptly repair the damage, and rent shall be reduced based on the extent to which the damage interferes with the tenant's reasonable use of premise. If damage occurs as a result of an act of the tenant or tenant's guests, only housing provider shall have the right of termination, and no reduction in rent shall be made. Any questions about 25, 26, or 27? Breach of contract, temporary relocation, or damage? All right, 28 is insurance. Tenants, guests, invitees, and licensees, personal property, and vehicles are not insured by the housing provider, manager, or if applicable, HOA against loss or damage due to fire, theft, vandalism, rain, water, criminal, or negligent acts of others, or any other cause. Tenant is advised to carry tenant's own insurance, renter's insurance, to protect the tenant from any such loss or damage. Tenant shall comply with the requirement imposed by tenant or on tenant by housing providers insurer to avoid an increase in housing providers insurance premium, or tenant shall pay for the increase in premium or loss of insurance. That's B, right? So if the tenant does something that causes my insurance to go up as the housing provider, they're going to be responsible for that difference. Tenant shall obtain liability insurance in the amount of not less than blank, naming housing provider and, if applicable, property manager as additional insured for damage to or upon the premise during the term of this agreement or any extension thereof. Tenant shall provide housing provider with a copy of the insurance policy before commencement of this agreement and a rider prior to any renewal. So that does not default to liability and naming the housing provider as additional insured. So if they want that, you want to make sure to check this box here and put what the amount of liability insurance is that you want to be included there. Any questions about section 28 insurance? All right, section 29, water beds, portable washers. Tenant shall not use or have water beds on the premise unless tenant obtains a valid waterbed insurance policy. Tenant increases the security deposit in an amount equal to 1/2 of the month's rent, and the bed conforms to the floor load capacity of premise. Tenant shall not use the premise on the premise portable dishwasher or portable washing machine. So that's not a regular dishwasher and a regular washing machine. That's the one that like hook up to sinks, because those tend to have more problems, more leaks, more dysfunction. So it's saying that you can't unless you give permission. The waiver of any such breach shall not be construed as a continuing waiver of the same or any subsequent breach. So, you know, if they have one breach of contract and we say, hey, it's okay this time, that doesn't allow them to just continue with the breach over and over again. Notices may be served at the following addresses or at any other locations subsequently designated. Here's where you would put the buyer's information, and here's where you would put the seller's information. Tenant estoppel certificate. The tenant shall execute and return a tenant estoppel certificate delivered to tenant by housing provider or housing provider's agent within 3 days after its receipt. Car form TEC. Failure to comply with this requirement shall be deemed tenant's acknowledgement that the tenant estoppel certificate is true and correct and may be relied upon by the lender or purchaser. That generally only comes into play if it's not the seller in the property, that if there's a tenant in the property. Any questions about 29 through 32? All right, mediation, consent with paragraphs B and C below. Housing provider or tenant agree to mediate any dispute or claim arising between them out of this agreement or any resulting transaction before resorting to court action. Mediation fees, if any, shall be divided equally among the parties involved. If for any dispute or claim for which this paragraph applies, any party commences an action without first attempting to resolve the matter through mediation or refuses to mediate after a request has been made, then that party shall not be entitled to recover any attorney fees, even if they would otherwise be available to that party in any such action. The following matters are excluded from mediation: unlawful detainer action, the filing of enforcement of mechanics lien, and any matter within the jurisdiction of a probate, small claims, or bankruptcy court. The filing of a court action to enable the recording of a notice of pending action or for order of attachment, receivership, injunction, or other action to enable the recording of or other provisional remedies shall not constitute a waiver of the mediation provision. Housing provider and tenant agree to mediate disputes or claims involving listing agent, leasing agent, or property manager, broker, provided broker shall have agreed to such mediation prior to or within a reasonable time after the dispute or claim is presented to such broker. After election by broker to participate in mediation shall not result in broker being deemed a party to this agreement. So we're agreeing to mediation. Attorney fees in any action proceeding arising out of this agreement, the prevailing party between housing provider and tenant shall be entitled to reasonable attorney fees and costs collectively not to exceed $1,000, except as provided in paragraph 33A. That's up here where we split it equally. Then we go into car form means the specific form referenced or another comparable form agreed to by the parties. Any questions about 33, 34, or 35? All righty, moving right along, statutory disclosures. It automatically checks the mold and dampness one, which is included as part of this form. Exposure to mold may have potential health risks. Tenant acknowledges receipt of the attached booklet titled Information on Dampness on Mold for Renters in California before signing this residential lease after sale agreement. Lead-based paint, if checked, the premise were constructed prior to 1978. So if it's before 1978, we need to check this box. In accordance with the federal housing law, housing provider gives tenant acknowledges receipt of the disclosures on the attached form LPD-RLAS and federally approved lead pamphlet. Periodic pest control, check if either applies. The housing provider has entered into a contract for periodic pest control treatment of the premise and shall give tenant a copy of the notice originally given to housing provider by the pest control company. Premise is a house, tenant is responsible for periodic pest controls, right? So if the tenant's responsible, we're going to check 2. And if the housing provider is going to provide it, we're going to go 1. And if we're just going to leave it up for discussion in case pests come into the picture, we don't have to check either box. Methamphetamine contamination. Prior to the signing of this agreement, housing provider has given tenant a notice that the health official has issued an order prohibiting occupancy of the property because of methamphetamine contamination. A copy of the notice and order are attached. You would check that box there. Bed bugs, housing provider has no knowledge of any infestation in the premise by bed bugs. Again, the seller is remaining in the property, so the seller would know better than we do. See attached bed bug disclosure, car form BBD for further information. Tenant shall report suspected bed bug infestation to housing provider or, if applicable, property manager and cooperate with any inspection and treatment of bed bugs. Housing provider will notify tenants of any units infested by bed bugs. Megan's Law database disclosure pursuant to 290-46, I'll get it eventually, of the penal code. Information about specified registered sex offenders is made available to the public via the internet website maintained by the Department of Justice at www.meganslaw.ca.gov. Depending on the offender's criminal history, this information will include either the address at which the offender resides or the community of residence and the zip code in which he or she resides. Neither housing provider nor brokers are required to check this website. If tenant wants further information, tenant should obtain this directly from the website. The residential environmental hazards booklet is G. Tenant acknowledges receipt of the residential environmental hazards booklet. Military ordnance zone, if applicable and known to housing provider, premise are located within 1 mile of an area once used for military training and may contain potentially explosive munitions, right? We would check those boxes if those apply. Flood hazard disclosure. Flooding has the potential to cause significant damage to personal property owned by the tenant. See attached tenant flood hazard disclosure. This is needed if the property is in a flood hazard zone. Death on premise, unless otherwise disclosed, a buyer or housing provider has no additional information that seller tenant previous other than what seller or tenant previously provided. That's the one that makes the most sense so far. And K is other material facts. So if there's anything else that needs to be disclosed, it would go in K there. Any questions about section 36, statutory disclosures? This is why we should keep the rent backs to 29 days or less. Okay. 37, Service Members Civil Relief Act, notwithstanding anything to the contrary in paragraphs 254, 256, or elsewhere in this agreement, the Service Members Civil Relief Act applies to this agreement in any effort to terminate it as specified in 2951 and 2955 of the Act. So that just means that, like, hey, if there's a service member renting the property and they're getting restationed to a new base, that they can break the lease early and it's not a breach of contract. Time is of the essence. Entire agreement. Time is of the essence. All understandings between the parties are incorporated into this agreement as terms are intended by the parties as final, complete, and exclusive expression of their agreement with respect to its subject matter and may not be contradicted by evidence of any prior agreement or contemporaneous oral agreement. If any provision in this agreement is held to be ineffective or invalid, the remaining provisions will nonetheless be given full force and effect. Neither this agreement nor any provision in it may be extended, amended, modified, altered, or changed except in writing. This agreement and any supplement, addendum, or modification, including any copy, may be signed in 2 or more counterparts, all of which shall constitute one and the same writing. Agency. Confirmation, the following agency relationships are hereby confirmed in this transaction. The housing provider's brokerage firm, that's where you would put in the seller's information there. Their name, the brokerage name, license number, is the broker of either the housing provider or both the tenant of the housing provider if it was dual agency. Housing provider's agent, this is where the listing agent's information would go. No. That is wrong. This is where the buyer's agent's information would go. Buyer brokerage. And this would be the buyer's agent. And then this, the tenant's brokerage firm, would be the listing agent's brokerage firm, and then the listing agent's name there for agency disclosure. The term of this agreement extends 1 year. A disclosure regarding real estate agency relationship has been provided to the housing provider or tenant who each acknowledge it receipt. That's only if checked. So if it's going to be longer than a year, check that box. Termination of agency relationship. Housing provider and tenant acknowledge and agrees that unless broker is the property manager or is specified in 2 below, once this agreement commences upon close of escrow, the broker will not represent the owner in any matter regarding the management of the premises and any representation duties that the broker may owe to and any agency relationship that broker may have with either housing party or tenant is terminated. So, right, so it's stating that, hey, we're helping negotiate this agreement, but once it actually, the close of escrow happens and we start the rental period, we are done. Okay. Notwithstanding paragraph 39C1, broker duties and responsibilities to either housing provider or tenant will terminate upon completion of the move-in inspection, car form MII. So that just prolongs it a little further. In case you're providing that MII form, you would check that box there for C2 if we're representing them through that period. Any questions about the agency section or the 37, 38, 39? Service members, time is of the essence, or agency. All right. 40 is notice of right to receive foreign language translation of lease rental agreements. California Civil Code requires a housing provider or property manager to provide a tenant with a foreign language translation copy of a lease or rental agreement if the agreement was negotiated primarily in Spanish, Chinese, Korean, Tagalog, or Vietnamese. If applicable, every term of the lease rental needs to be translated except for, among others, names, dollar amounts, and dates written as numerals and words with generally no accepted non-English translation. Receipts is 41. If specified in paragraph 4 or 5, housing provider or broker acknowledge receipt of funds. 42 is other terms and conditions. If checked, the following attached documents are incorporated into this agreement. It gives you a whole bunch of different ones you can check, to which the bedbug disclosure, the tenant flood hazard disclosure, and the rent cap and just cause addendum are always included as part of this form. The other ones are the key safe, lock safe addendum, the lead-based paint, the lease rental mold and ventilation addendum, the parking space and storage disclosure. You could add all of those in. Other documents or addendums. Here gives you a box that you could include other things. And then remember, way back at the beginning, it talked about how housing provider was going to provide a phone line to the property. Here in the other line, remember, we just added housing provider will not provide nor maintain phone line to the property, no additional rules and regulations, because those were two things that were mentioned earlier in the agreement that we covered last time that we wanted to make sure to add clarity to at the end of this one. Any questions about the 40 through 42, 40, 41, or 42, receipt, notice of the foreign translation or other terms and conditions? All right, 43 is the legally authorized signer. Wherever the signature initials of the legally authorized signer identified in paragraph 46 or 47 appear in this agreement or related documents, it shall be deemed in a representative capacity for the entity described and not in an individual capacity unless otherwise indicated. The legally authorized signer represents that the entity for which the person is acting already exists and is in good standing to do business in California and shall deliver to the other party upon request evidence of authority to act in that capacity, such as, but not limited to, applicable portion of the trust or certificate of trust, letters of testamentary, court order, power of attorney, corporate resolution, or formation documents of the business entity. 44 is interpreter translator. The terms of this agreement have been interpreted for the tenant in the following language. Housing provider and tenant acknowledge receipt of the attached interpreter translator agreement, CAR form ITA. You would check that box if there is an interpreter or a translator. The 45 is the premise is being managed by owner, or if checked. So the default is premise is being managed by the owner. Otherwise, it's the housing provider's brokerage firm in the real estate brokerage section, tenant's brokerage firm in the real estate brokers section, right? So it's either by the buyer's brokerage, it's being managed by the listing agent's brokerage, or a property management firm immediately below. So for the most part, it's going to be managed by the buyer of the property, which would be the owner. Housing provider and tenant acknowledge and agree. Brokers do not guarantee the condition of the premise, cannot verify representations made by others, cannot provide legal or tax advice, will not provide other advice and or information that exceeds the knowledge, education, and experience required to obtain a real estate license. Notice it doesn't say that the agent has, it says obtained for that needs to be obtained a real estate license. Furthermore, if brokers are also not acting as housing provider in this agreement, brokers do not decide what the rental rate a tenant should pay or a housing provider should accept, and do not decide upon the length or terms of the agreement. Housing provider and tenant agree that they will seek legal, tax, insurance, and other desired assistance from the appropriate professionals. Tenant and seller agree to rent the premise on the above terms and conditions. Entity tenant. So if here we're into the signature box, this is the same as like the residential listing agreement or the residential purchase agreement. If the tenant is not themselves, we would check this box here. If they're operating in a representative capacity disclosure, boom, there. And then this is where they sign. And then the housing provider or buyer, owner or agent from the owner agrees to rent the premise in the above terms and conditions. entity housing provider. So this would be, again, if they are a trust, it was buying the property, or a corporation or something like that, we would mark that box there. And then fill out this section. And then everybody signs down here as far as the buyers go. Okay, same thing here as with all those. If there's 2 or more signers, we would use the ASA form, the additional signature addendum. Any questions about sections 45, 46, or 47, the signature boxes, or the management of the property? All right. Yep. Question?
No, I was just gonna say no, ma'am, no question.
All right, fabulous. The last page has the real estate broker signature on it, which is right here. Real estate brokers who are also not also a housing provider under this agreement are not parties to the agreement between housing provider and tenant. Seller agency relationships are confirmed in paragraph 39. Cooperating broker compensation, unless otherwise agreed, compensation for this residential lease after sale is included in any compensation received from the purchase of the real property described in this agreement, or if checked, for the amount specified in a separate written agreement between housing provider's broker and tenant's broker. So, right, you're not getting paid anything else outside of the real estate transaction for drawing up this form for them. And then here's where everybody signs this document as far as the brokerages go. Any questions about the RLAS form? All right, so that's what you use if there's going to stay in possession of the property 30 days or more. 29 days or less, you do the SIP, the seller in possession after the close, which we covered last week. You can watch that recording. The other forms that are included as part of this document, I'm not going to go over these in detail, but one is the bed bug disclosure, talking about little bed bugs. The next one is the tenant flood hazard disclosure, where you need to disclose whether it is or isn't located in a special flood hazard zone or area of potential flooding. You should be able to get this off the NHD report, which was provided as part of the purchase transaction. So it's either not located in a special flood hazard zone or an area of potential flooding, or it is, and you would check this box here under 1. Okay. Everybody signs that one and reads it. Then you've got the rent cap and just cause addendum here that gets completed as well as part of the RLAS. Please don't exclude these forms because it says that they are included. It also includes this information on dampness and mold for renters in California. So that's the pamphlet that they talked about, is included automatically as part of this agreement. Okay, any questions about those additional forms that are included? Telling you people, keep it to 29 days or less. All right, we just added like 16 pages because we had the, instead of like 2. All right, we're gonna move on to the contingency for sale of the buyer's property. So if we are making an offer on the property and the purchase of this property is contingent on the buyer selling a property, right? They're getting funds from it. They can't afford both as far as the pre-approval process. They don't want 2 mortgages, and they want the purchase of this one contingent on that one either entering into contract or closing. We use this form here, the COP form. There's a place for this on the residential purchase agreement in the contingency section. It's right in the L section. I think it's like L9. It's like 3L9. Is you check the little box for it's contingent on the sale of buyer's property, and you're going to include this form. This is an addendum to the purchase agreement, and you're going to date it, right? This is where you're going to put the date in the upper left-hand corner of the top of page 1 of the purchase agreement, the date that's actually printed up there. Property address, you're going to put the buyer's names, the seller's names, and here you're going to put in the buyer's property address. 1, 2, 3, Buyers Street in Buyers City, California. Okay. So you're going to put in that address. It doesn't matter whether it's in California, Idaho, Washington, Texas, Tennessee, wherever that property is located, you're putting in that address. The buyer's property contingency. The agreement is contingent upon the buyer entering into a contract for the sale of and closing escrow on buyer's property. So the default is entering into escrow and closing escrow. Okay, so it's 2 parts. Now, if you only cared about one part of that, we could go with either B or C, which would be only entering into contract for sale of buyer's property. Maybe the buyers just want to know that, hey, we at least started the escrow process. We don't want to close on this property until we know that we're moving forward with an escrow on the property we're trying to sell. We don't really care that it closes first. Then we would check that box there for 1B. That would be only entering into contract. If we wanted to check C, it would be only the close of escrow of the buyer's property because it's already in escrow. Okay, so 1 is both entering into contract and the close. The second is just entering in the contract. And C is, hey, we're already in contract on the property we're trying to sell. We just want to make sure it closes. We would check this box here for C. If we check C, then we would, it says, which is already in escrow with blank escrow company, escrow number, a copy of the contract for sale of buyer's property, and the contact information and escrow number for that sale. Collectively, escrow evidence is attached to the COP form or will be delivered to seller within 2 days after acceptance. So the default is, hey, we're including this form. Our property is already in contract. Here's the evidence of escrow. And evidence of escrow is a copy of the purchase agreement for the buyer's property. Okay, copy of the contract for the sale of the buyer's property and the contact information and escrow number for that sale. Okay, we had this question come up like last week or the week before. There was like a property with multiple dominoes, and it was like the third domino down the line was saying, hey, can I get copies of the purchase agreements for the other properties that are part of this domino? And the question was, can we even provide that? It states right here that we actually not only can, but have to provide that because it's the evidence of escrow. So make sure you're prepared to provide a copy of that purchase agreement. Buyer entering any questions about the intro or section 1, the buyer's property contingency. Okay. 2 is buyer entering into contract for sale of buyer's property. If 1A or B applies, so right, 1A or B, either the default or entering into escrow, then section 2 applies. The buyer shall have 17 days after acceptance to enter into contract for sale of the buyer's property. So the default is 17 days. We accept the offer today. Today is day 0. They've got 17 days to make sure they get that property on the market and that it enters into contract. Okay. By the earlier of the time specified in 2A, which is the 17 days, or within 2 days after buyer entering into contract for the sale of the buyer's property, buyer shall deliver escrow evidence to seller and escrow holder. So that's just saying, hey, either at that time frame of 17 days, or if we enter into contract sooner, within 2 days of entering into contract, the buyer is going to provide a copy of evidence of escrow, which again is the purchase contract, and then the contact information for the escrow company handling that transaction. 3 is listing and MLS status of buyer's property. This is for 1A or 1B, right? 1A or 1B up here, the buyer entering into contract and close, or just entering into contract. Buyer has signed a listing agreement for buyer's property or shall within blank days after acceptance sign a listing agreement. So have they already signed one, or are they going to sign one? It defaults to they've already signed one, but if not, we would check this box here and put how many days after acceptance they're going to sign that. And then we're going to put in the real estate brokerage for which they're signing the agreement with. Are they listing the property with you or somebody else? Whoever that is, we're going to put in that information there. The buyer's property is or will be submitted to the MLS in the geographical area for which the buyer's property is located, or the buyer's property will not be submitted to the MLS in the geographical area for which the buyer's property is located, right? Is it being listed in the MLS or not? If it's not, we're going to check this box here, which says that it's not. The default is it's being listed in the MLS in the geographical area. The buyer shall deliver to seller evidence of both the listing agreement and, if applicable, the MLS listing within 1 day after acceptance if buyer's property is already listed with real estate brokerage, and if not already listed within 1 day after listing with real estate brokerage, right? So not only do we have to provide them a copy of the purchase agreement once it enters into contract, but we're also required to provide them a copy of the listing agreement and a copy of the MLS printout within 1 day of it going on the market. Any questions about sections 2 or 3? All right. Section 4, the close of escrow of buyer's property. So this is if 1A or C applies. Remember, 1A was entering into contract and the sale, and C is just the close of escrow. We're already in contract. Buyer has until the following time to close escrow on the sale of buyer's property. The scheduled close of escrow of the seller's property, right? So they can either close on the same date, or if checked no later than 5 days prior to the scheduled close of escrow of the seller's property. Once buyer's property closes, buyer can no longer use this contingency to cancel the agreement. So it defaults to, hey, it just has to close. It just has to coincide with this closing that we're negotiating now. If we check this box here, we could say that, hey, it has to close before the close of escrow, right? So if we're scheduled to close on the 30th and we're saying 5 days, then this one needs to close on the 25th. Okay, but the default is it just has to coincide. The same day is fine. Status of the sale of the buyer's property. If 1A or C applies, buyer agrees to keep seller informed about the status of the transaction for the sale of the buyer's property, including any changes, modifications, addendum, or amendments to the terms of the accepted offer, or delays or removals of contingency. Update. So, right. So anytime we change any terms of that contract, we add an addendum, we add an amendment, we change anything, something's modified, or there's a delay in something happening by the time frame, or somebody removes those contingencies, we have to keep the seller updated. Within 2 days after the seller's written request, but no earlier than the applicable time to remove the contingencies in the contract for sale of the buyer's property, buyer shall deliver to seller evidence of the removal of those identified contingencies, right? So, hey, we have to provide, we get the contingency removal from our buyers that are buying our buyer's property, and we provide those to the seller so they can see that, hey, we're moving along and all those contingencies are being removed. The reason that we have to do that is if that buyer walks away from that property that we're selling as a buyer, we have the right, if we've done 1A or C, which is the close of escrow of the property, we have the right to cancel this whole agreement. Okay, so they just want to be kept up to date. Cancellation of buyer's property. If the buyer's property is in or enters escrow and either party to that escrow gives the other a notice of cancellation of contract, the buyer within 2 days thereafter shall deliver to seller written notice that cancellation. Just so you know, if I'm the listing agent on a property, I probably want this moved to like 1 day. If that property gets canceled on, I need to know immediately. Okay, any questions about 4 or 5 or 6? I think we just did 5 or 6. No, we did 4, 5, or 6. All right. Backup offers. This section's really important. Backup offers and the seller right to require buyer to remove contingencies or cancel. Backup offers. After acceptance, the seller shall have the right to continue to offer the seller's property for sale for backup offers. The party acknowledges that the brokers shall not violate MLS rules requiring accurate property status reporting. This means that, hey, we can move that property to contingent show, and we can put in the confidential remarks that we are accepting backup offers. Okay, if somebody calls us, absolutely, we would take a backup offer. We can serve a notice on this contract. Okay, so, but we still have to we have to move it to contingent. We can't leave it as active. Removal of buyer's contingencies and proof of funds. Unless paragraph 7C3 is selected, which is down here, no right to notify buyer. If seller accepts a written backup offer and provides buyer a copy of the signed accepted backup offer within the time specified in paragraph 7C1 or 2, seller shall have the right to give written notice to buyer in writing to remove this contingency, remove the loan contingency, if any, and provide verification of sufficient funds to close escrow without the sale of the buyer's property. Seller may use the bottom of page 2 of this form to comply with the written notice requirement of this paragraph. If buyer fails to complete these actions within 2 days after delivery of such notice, seller may then immediately cancel the agreement in writing. Okay, so the contingency removal, and we'll talk about the timeframes here in a second, but not only can we give notice for them to remove this contingency, but they also would need to provide proof that they can close on this transaction without having to sell their property. Okay, time to give notice to remove contingencies. Seller shall have the right to invoke the notice provisions in paragraph 7B, which we just went over. One is it defaults to immediate right to notify buyer anytime after acceptance. We get a backup offer tomorrow, we can serve that 2-day notice to perform, and the buyer has to provide proof. They have to remove the contingency, provide proof that they can close without the sale of their property, and also remove the loan contingency. Okay, that's the default. The second option is delayed right to notify buyer. This is what we see most often, no earlier than 17 days after acceptance. The reason we see this is oftentimes if the buyers have asked for 17 days to enter their property into contract, they oftentimes will then also ask for a delayed right of no earlier than 17 days after acceptance to be notified of a backup offer. Okay, so that usually coincides. The third one, which is what I usually submit with my offers, unless it's a super competitive offer situation, is no right to notify buyer. Now, as a listing agent, just so you know, I rarely ever would accept a no right to notify buyer, but this is how I submit it for my buyers. The seller shall not have the right to invoke the provisions in paragraph 7B during the entire term of the agreement. They can't take a backup offer and cancel on me. My buyers can't purchase this property without selling their property, and I want to protect them, and I don't want the seller just to be able to take a backup offer at any time and run away from us. Okay, so that's usually what I check for my buyers. Again, as a listing agent, I rarely ever will accept an offer with that box checked. I'll counter it. What are your questions or any questions about 7?
So if you were the seller and you're countering the delayed or box number 3, the no right to notify, would you counter them with number 2 then? And then just put the 17 days so they at least have time to, basically be under contract?
Yeah, so yeah. Oftentimes I will counter with a delayed right to notify buyer, and usually regardless of what they say up here for how many days it's going to take them to get their property in escrow, I usually put about a 14-day time period on there. So I usually counter delayed right with 14 days.
With 14 days because you're trying to make sure that they're getting all their inspections done before that time for the inspection contingency? Or
yeah, we'll talk about that part here in a minute because it's a whole nother section. But just because like in 2 weeks, I want to know that, hey, we're going to be moving forward or we're not. Like, what are we doing? Or I can move forward with a backup offer. I'm going to give you guys 2 weeks to get your act together and make it all happen. And if at that time, I'm going to have the right to move forward with a counter offer or a backup offer.
Okay.
Yep. Any other questions about section 7? Okay, removal of contingencies. This contingency can only be removed in writing, even if buyer removes this contingency, unless buyer also performs all actions pursuant to paragraph 7B. Seller retains the right to cancel under paragraph 9. So again, they retain the right to cancel under paragraph 9, even if they remove this contingency, because they also have to remove the loan contingency and provide proof of funds, is what's in 7B. Okay. Seller right to cancel. The seller may cancel this agreement in writing as follows. After first giving buyer a written notice to remove the buyer contingencies and provide proof of funds below. If buyer fails to take all actions specified in paragraph 7B. After first giving buyer a notice to buyer to perform, if buyer fails to enter into contract for the sale of buyer's property within the time specified in paragraph 2A. So keep in mind that if we've hit 17 days and we left it at the default, buyer still hasn't entered into contract, we still can't just cancel and move forward. We still have to serve that notice to perform and give them 2 days before we can cancel. Okay, so just kind of keep that in mind. After first giving buyer a notice to perform, buyer fails to close escrow for the sale of the buyer's property within the time specified in paragraph 4, right? So again, we can't just cancel on them. We have to serve the notice, a notice to perform. Probably at the same time, that would be mainly if we specified that it needed to close before the close of escrow of our scheduled close of escrow, then you would be able to do that. After first giving buyer a notice to perform, if buyer fails to deliver escrow evidence within the time specified in paragraph 1C or 2B, that's a copy of the purchase agreement and the contact information for the escrow holder for their property. After first giving buyer a notice to perform, buyer fails to deliver evidence of listing the buyer's property or, as applicable, the submission of buyer's property to the MLS within the time specified in paragraph C, right? The buyer is delaying and hasn't even gotten their property on the market. We can serve that notice to perform. Buyer fails to deliver evidence of removal of contingencies of the sale of the buyer's property as specified in paragraph 5B, right? They are required to provide that evidence. Or if buyer gives notice to seller that either party's cancellation of contract for the buyer's property. So if the buyer's property falls out of escrow, the seller then has the right to cancel the contract. And notice that here, I don't know why on F, it feels like it probably should be a notice to perform here, whereas G, I don't believe requires a notice to perform. Their property falls out of escrow, then you can talk about how you want to move forward on that, but the seller can cancel. Any questions about section 9? In case you guys were wondering, we're not going to make it to the SPRP. We'll cover that next week. Buyer right to cancel. 10. The buyer may cancel the agreement in writing if prior to the buyer's removal of the buyer's property contingency specified in 1A, B, or C. A would be 1A or B. Buyer is unable to enter into contract for buyer's property within the time specified in 2A. Buyer can cancel this agreement. They walk away with their deposit. They're not in breach. Either party for buyer's property gives notice to the other to cancel the contract for purchase of the buyer's property if it's in the close of escrow. That's right. Then the buyer can cancel this agreement. Or 1AC, buyer is unable to close escrow on buyer's property within the time specified in paragraph 4. So those are all the reasons that the buyer could cancel based on this contingency. Time of performance of contract obligations and delivery of buyer's deposit. Here's what Maciel was touching on here. Contract obligations other than deposit. So all the time periods in the agreement. So this is the purchase agreement for inspections, contingencies, covenants, close of escrow, and other obligations, excluding those in this addendum, shall begin as specified in the agreement. So they're saying that, hey, if we accept the offer today, right? If we leave this as the default, you better account for that in your offer. So if the buyer's property isn't currently in contract, and we're asking for 17 days to enter into contract, and we're probably going to have a 20 or 30-day close of escrow, the buyer may need potentially 47 days to close escrow, right? 30 plus 17. So if we leave this as a default and we wrote the offer with a 30-day close of escrow, this is stating that the default is everything starts immediately. That close of escrow time frame, the inspections, everything starts immediately. So you probably want to write your offer with a longer close of escrow to account for time to enter into contract and time to close escrow. Now, if the property is already in escrow, it's not a problem. If we check this box here, it's on the day after buyer delivers to seller any of the following: evidence of escrow for the buyer's property, buyer's election in writing signed by buyer to begin the time periods, or buyer's removal of this contingency for the sale of the buyer's property. So if we check this box, then it's a delayed start on all the time periods in the contract. We see this quite often. It's very common, especially in a non-competitive market, that, hey, we're entering into contract, but we're not actually going to start our inspections and our loan contingency and our appraisal contingency until we are in contract on the property we have to sell in order to do this purchase. Okay. In a very competitive market, you're going to start it immediately. You're just going to adjust your time frames for that time that you might need to get your property into contract. Or if the property is already into contract, you don't have to worry about it. We're just going to continue on as specified in the agreement. The only one that's separate from that is the buyer's deposit. The buyer's deposit shall be delivered to escrow within the time specified in the agreement is the default. I usually leave that as the default. I want the buyer's money in the escrow holder's hands immediately. If we check this box here, then it's within 3 business days after buyer delivers to seller any of the following: evidence of escrow for buyer's property, buyer's election in writing signed by buyer to begin the time periods, and buyer's removal of the buyer's property contingency. Questions about section 11? Okay, everybody's good? That brings us to the end of the form here. By signing below, buyer and seller acknowledge that they have read, understand, accept, and received a copy of this addendum. Buyer signs, seller signs. Now keep in mind that you can counter any items on this. So if the buyer is going to sell their property, this should be submitted as part of the offer. And any item on here can be countered just like it would be countered in the regular purchase agreement as well. So if we're countering anything, it can be part of this. Okay, buyer signs, seller signs, even if there's a counter offer, seller still signs this because the counter offer would be a counter offer to the purchase agreement, and it's noted on the signature line for the purchase agreement that we're countering. Okay. Now, the bottom section here is the removal of the contingencies. So if the seller has the right up here under this section here, it would be 7C, either 1 or 2, to accept the backup offer, and they want to move forward with that backup offer, then we can use this as that notice to remove the contingency. Seller hereby gives notice to buyer to remove the sale of the buyer's property's contingency, remove the loan contingency, if any, and provide verification of sufficient funds to close escrow without the sale of the buyer's property. If buyer fails to complete these actions within the time specified in paragraph 7B, then seller may then immediately cancel the agreement in writing. This notice to remove buyer contingencies and provide proof of funds is not to be delivered until the time specified in paragraph 7C. So you can't do this until this time frame right here. Okay, and then we can serve this notice to perform. So when we first sign this in agreement, we're just signing this top line. But if we get that backup offer, then we can sign this and resubmit it back to the buyer as notice that they need to do all 3 of those actions: remove the buyer's property contingency, remove the loan contingency, and provide sufficient proof of funds to close escrow without the sale. All 3 of those have to be done. Otherwise, the sellers can cancel this and move forward with that backup offer. Keep in mind, the sellers also need to provide a copy of that backup offer to the buyers, proof that they have a backup offer. They can't just cancel and put it back on the market. Okay. In addition to that, keep in mind that if you are representing a buyer and you have a contingency for the sale of the buyer's property, when you do your contingency removals, please don't check the buyer hereby removes all contingencies until this property is sold. Because once we check the box that we're removing all contingencies, we've removed the contingency for the sale or close of escrow of this property. So just kind of keep that in mind. You want to do all contingencies except, entering into escrow of buyer's property or close of escrow of buyer's property. We want to make sure that we leave that outstanding until the property actually closes escrow. Any other questions regarding the contingency for the sale of the buyer's property? The COP form. No? Fabulous. Then it is 10:04. We are done for today. I really appreciate you guys joining me for our summer series, Car Forms. Hope you got some good information on both finishing up that RLAS, the residential lease after sale, and the contingency for the sale of the buyer's property. I'll look at what we're supposed to be covering next week, but we will definitely roll the seller's purchase of replacement property into next week. So we'll be covering that next Thursday, and then we'll see what other forms we can get through that were scheduled. Otherwise, we'll just keep, delaying them a little bit further. And then remember that we also have the list and sell foreclosure properties training happening today at 11 o'clock. If you don't have that link, shoot me over a message. I'll make sure you have the link for that training. If you want to join us, Robert from Southern California, who's built his business that way, is going to be sharing that information with us today.
Will that one be recorded, Amy?
It will be recorded.
Okay. I have an appointment, so that's why I was just, can't be on it. So
it will be recorded.
Cool.
Fabulous. Anything else before we close up for today?
Great info. Thank you.
All right, everyone have a fabulous day, and we will see you at 11 o'clock. Otherwise, I will see you next week.